All right, let's move to our final case today, and that would be ZETLEY and Anchorage Development versus Riverside Builders. All set? Ms. Waldball?
Your Honor, may it please the Court. The first issue on this appeal is whether the Florida Supreme Court's decision in Kislak is still the law of Florida. It is, and under Kislak, which this Court cited in S&W Airvac Systems for the very point, in order to establish their claim for breach of a joint venture agreement, plaintiffs had to prove both the elements of a joint venture as well as every element necessary to be embraced within the concept of a contract. They did not do so. They contended that there was a joint venture to construct a particular condominium project, and Mr. ZETLEY was to be the funding partner. He was to fund the construction. But the plaintiffs did not even agree among themselves as to what ZETLEY's funding obligation was, what risk he would assume on this project. As a result, they could not possibly have had a meeting of the minds with Mr. ZETLEY in that regard.
Didn't Perry testify that Mr. ZETLEY agreed to fund the entire project to the tune of $4.8 million, and then the other...
That was what Mr. Perry said.
Right, and the other party said he couldn't recall the amount, but that he did agree to fund the project, correct?
No, Your Honor. And that's the crux of the issue. He did not. Mr. Perry said he agreed to pay $4.8. Mr. Grace said the plaintiffs had to give hard cost numbers before Mr. ZETLEY would agree to anything. He said, Mr. Grace said Mr. ZETLEY would not fund the project unless he was sure it was a safe investment. And he said he agreed to fund the project as long as the costs were not out of line with the estimates, if it made sense.
Didn't he also say at 620 that that ZETLEY agreed to build the project within the initial budget, and that if they exceeded the budget, that Graham Perry's profit participation would be reduced by any excess costs? Was that also his testimony?
I'm sorry, you're going to have to speak up. I just could not hear you.
Okay. Didn't he also testify that that Mr. ZETLEY agreed to fund the project to the extent of the initial budget that they offered, the 20 items that they said would be in the initial budget?
With the preliminary budget.
Right.
But he said he still was clear that they had to get hard numbers. Those preliminary estimates had not been bid out. They weren't hard numbers, and he could not have been clearer that the plaintiffs had to give hard cost numbers, in their words, before he would agree to anything. So yes, they were looking at building this project, but the plaintiffs had to come forward with a contract to build it in accordance with the preliminary estimate. And they
doesn't matter who comes forward with the contract. I mean, in other words, they have an agreement that they're going to build this condominium project, and one of them is going to provide the money, and one of them is going to provide the design, and one of them is going to provide the marketing. Does it matter who finds a contractor that they're all happy with?
Well, it was Mr. I'm not sure I understand the question, but it was under plaintiff's theory of this joint venture, it was Mr. ZETLEY's obligation to fund a contract.
Right.
And they came forward with different kinds of contracts, never by their own admission a contract that was complete, never by their own admission.
But if Mr. ZETLEY, as opposed to either the plaintiffs, found a contractor that he was happy with, why can't he go to the two plaintiffs and say, look, I found a contractor who's willing to do it for $4 million. He's a good contractor. How about if we have him do it?
He could have done that, Your Honor, but remember the question is when the parties walked out of the July meeting, at that point in time, the plaintiffs say there was an agreement that they would be the ones who would build this project. They would be the ones who would get the construction contract. And that all Mr. ZETLEY was to do was to fund the contract, to fund the construction contract.
Can the jury consider the course of conduct by the parties after this initial meeting in determining whether a partnership agreement had been reached?
The parties' course of conduct after that July meeting is inconsistent with a joint venture agreement. According to the proposal, Mr. ZETLEY was to form a corporation which would then issue shares, 50% to the two plaintiffs, 50% to Mr. ZETLEY. That didn't happen. According to the proposal, the plaintiffs were to provide a construction contract in accordance with their preliminary estimate. That didn't happen either. The first thing they did was come back with a cost-plus contract.
Well, between the time of the July meeting and the time where Mr. ZETLEY formed a new corporation and signed a contract with the contractor, didn't the plaintiffs incur expenses which Mr. ZETLEY reimbursed them for?
Yes, they did.
All right. Well, is that consistent with that they had an agreement, or is that consistent with they had no agreement at all at the first meeting?
I think it's inconsistent with a joint venture in which
So he's just paying them, reimbursing them expenses voluntarily?
It's because they're moving forward. There's no question the parties were trying to move forward to see if they could, in the plaintiff's words, negotiate a contract that would be acceptable to Mr. ZETLEY. And he was assisting them in the utmost of good faith. As they moved forward, they incurred costs. He reimbursed them for it, so they were not out of pocket. But that's inconsistent with the notion that there was a joint venture where he was to pay all of the cost. Under a joint venture, he should have paid the cost. He shouldn't have been asking them to sign a note for those costs.
Let me ask you to address this language in Kislak. That case, in a part that you didn't quote, says that the agreement to join a partnership or joint venture need not be expressed or embodied in a formal agreement or particularly specify or define the rights and duties of the parties. It may be inferred from the conduct of the parties or from facts and circumstances which make it appear that a joint enterprise was in fact entered into, and the consideration for a contract of joint venture may be a promise expressed or implied to contribute capital or labor to the enterprise. And then, I mean, I just think there are so many cases in which the courts look at the conduct of the parties and say, yes, they entered a joint venture agreement, they entered a partnership, it's clear from their conduct. I just find all of those cases and the language of the Florida Partnership Act and the revised Uniform Florida Partnership Act to be inconsistent with your position that every detail of every undertaking that the partnership is going to foresees has to be hammered out and signed in a detailed agreement before there is a partnership, which seems to be your argument.
Absolutely not. Certainly not. Kislak makes it clear, and other cases make it clear. You don't have to have every I dotted and every T crossed. But what you do have to do is have an agreement on the essential terms of the contract and what the essential terms of the obligation. And here, there was never an agreement on exactly what risk Mr. ZETLEY would take, on exactly how much he would fund under what kind of a contract. And Judge Lawson, that's why we see coming out of the meeting not them coming up with a guaranteed maximum price contract for $4.8 million with the contractor's fee.
But this wasn't just a partnership or an agreement, according to the plaintiffs, to build a building. It was an agreement to develop a project which would involve purchasing land and advertising and design and all sorts of other things. I mean, only one of the cost items was the construction cost. Now, it was the biggest by far, but I mean, if if your client agreed to fund the project under KISLAC and certainly the Uniform Partnership Act, why isn't that enough?
Because he has to have had an agreement certain as to what he is going to fund. The plaintiffs admitted he didn't come out of that meeting in July giving them a blank check and saying, we'll fund this project no matter what it costs. They couldn't, Mr. Gray at least, could not have been clearer that the agreement was, I want to see hard cost. I want to see if this is going to make sense. I want to see if you really can come up with a contract that we will build this. And that was what they were concerned with. It was the construction cost. They weren't concerned with all of the other little, advertising. They were concerned with, can we construct this condominium for what your preliminary estimates are? And that's why the plaintiffs went out and tried to get a contract that would be consistent with their preliminary budget. And they were never able to do that. They came up with a cost plus that was more than their preliminary budget, that had a contractor fee more than their preliminary budget. Then they came up with a fixed fee contract that had the fixed fee blank and had an even bigger contractor fee. So they never are presenting to Mr. ZETLEY a contract that has hard numbers in it consistent with the preliminary budget, that makes sense to him, that's a safe investment. All of those things are what the plaintiff's testimony itself, and in their brief on appeal, they say, he agreed to fund the project as long as the costs were not out of line with the estimates if it made sense. That's an agreement. That's a classic agreement to agree. It's a classic, you bring me an agreement that does what you say in your preliminary budget, and we'll go from there.
What's the effect? That's
a classic agreement to agree, and under this court's authorities and all kinds of Florida authorities, that's just not enforceable.
What's the effect of the jury verdict on your position?
We would say none. We would say we were entitled to a directed verdict at the close of
was the jury verdict, was it a detailed verdict or was it a simple we find for the plaintiffs?
There was a finding on the joint venture claim against Mr. ZETLEY, and then there was a finding on the unjust enrichment claim against Anchorage. We also would say, Judge, as is in our additional point, that the jury verdict was tainted by the fact that the court did not instruct the jury that there had to be a meeting of the minds on the essential terms, which was our theory of the case. The most essential term from the standpoint of Mr. ZETLEY was, how much am I at risk for? What's my obligation of funding this going to be? And the judge declined to give that instruction, saying it wasn't the law, and under KISLAC, which is still the law of Florida, that instruction.
Let me ask you this: on your second issue, when there was a discussion of the proposed jury instruction on standard of review that you put forward. And then counsel for Mr. ZETLEY said, well, I guess, in other words, formation of a partnership does not require a showing that the parties intended to create a partnership, only that they intended to do things that constitute, and it goes on, which appears to be an agreement with the court's conclusion that this proposed instruction didn't necessarily fully and accurately reflect Florida law. And then there was no further objection to the instructions. How did you preserve this error in light of what appears to be a concession and the failure to object thereafter?
I think the concession went to the prior part of the instruction. As I read the charge conference, we were acknowledging that the instruction with respect to the basic elements of a joint venture was correct.
Well, there was no controversy about that part of the instruction, was there?
Oh yes, there was back and forth, and we had a requested instruction, and the plaintiffs objected to it. So there was considerable back and forth. And at some point, they came up with an agreement that was an instruction that was agreeable to both of the parties. But at that point, trial counsel for the defendants did ask specifically for the written instruction for the additional instruction on meeting of the minds, on no enforceable agreement if there's still being negotiating, and did ask for that, and it was at that point that the judge just said, that's not the law of Florida, and he cut him off. And under this court's authority, which we've cited in our brief, I believe it's a nude court, as long as you have requested a correct instruction, you've preserved it. You don't have to object again.
Let me ask you, in your brief, and it seems on this point you're in agreement with the appellees that FAR statutes in the Lytall case confirm that the necessary meeting of the minds may be implied from the parties' conduct in course of dealings as partners. Would you agree that's a correct statement?
Yes, you can show the course of a meeting of the minds by the course of conduct, but
all right, but in the proposed jury instruction, is there any reference to the fact that the meeting of minds can be shown by course of conduct?
There was not, and that was not the objection. Had there been, it would have been an easy enough thing to have added it in.
But does that make the proposed instruction incomplete?
No, Your Honor, it did not make it incomplete to the extent of what the instruction was intended to address. It was only intended to address our side of the case. They got an instruction that said it can be implied. We asked for one that said yes, but you still have to have a meeting of the minds on all of the elements of the contract, and you can't still be negotiating them. We asked for that simple instruction that went to our theory of the case, and if the plaintiffs wanted additional instructions, they were free to ask for them at the time, but that wasn't the issue that it went off on. It went off on, the trial court accepted their argument at the time that they did not need to prove an agreement. I would like to address, I know I'm running out of my time, so I'm going to do it in 60 seconds on just enrichment. And I simply want to make the point that the plaintiffs have conceded that they did not prove the value of the services they provided. They've relied on a second district case, the Montage case, as entitling them to get half of the products of the project that was completed. But Montage was a case in which property was misappropriated by the defendant. Property was the benefit that the defendant got, and so it was the value of the property that was the unjust enrichment. It was not a services case. In a services case, under this court's authorities, you have to prove the value of the services. Thank you, Your Honor.
All right.
May it please the Court, I'm Kathleen Scambus. I represent the appellees, Riverside Builders of Brevard, Inc., Mr. Gray and Mr. Perry. Appellants would very much like for this case to be about a construction contract. This case is not about a construction contract. This case is about a development partnership. And the construction contract was an operational detail that was to be worked out by the development partnership. The partnership began at a meeting in July of 2002, at a meeting in the office of Riverside Builders. Mr. Gray and Mr. Perry presented their proposal to Mr. ZETLEY, who was an experienced businessman. And the testimony was, at the end of the day, they shook hands and agreed to go forward with the project. There was nothing in that proposal, which is Plaintiff's Exhibit Number 1, that required a guaranteed fixed price contract. No one understood that that was a requirement going forward until a contract that was not a guaranteed fixed price contract was presented to Mr. ZETLEY. By that time, the parties had already demonstrated by their behavior, in addition to the agreement around the table at the meeting, that they were engaged in a development project. Mr. Perry and Mr. Gray had undertaken substantial marketing efforts. There were efforts to get a site plan approved. There were architectural drawings drawn up. Mr. ZETLEY had put forth money to fund those things. There was no reason for anyone to believe that a construction contract as an operational detail of this development partnership could not be worked out. Either after that meeting in July of 2002, everything was in order and enough details had been discussed for Mr. ZETLEY to proceed with the partnership, which is consistent with his actions going forward, or Mr. ZETLEY had decided to hang back and let Mr. Perry and Mr. Gray go forward as if there was a development partnership, obtain an assignment of the contract to purchase the land, and then snake them out of their money and their interest in the project. Now, the jury was entitled to conclude that Mr. ZETLEY's professed insistence that a guaranteed maximum price contract was essential to this partnership, or they were entitled to believe and conclude that that was a ruse to obtain Mr. Perry's and Mr. Gray's interest. The jury was properly instructed on both the elements of a partnership and the definition of a partnership, and they obviously concluded that Mr. Perry either had a deal and all of this was consistent with it and then decided to back out of it, or that he let them believe he had a deal and snaked them. And there was plenty of testimony in the record that would have allowed the jury to conclude that. Kislak.
For the jury to reach the verdict they did, would they have to believe part of the testimony of one plaintiff and reject part of the testimony of that plaintiff, and then believe a different part of another plaintiff's testimony and reject a different part of that same plaintiff's testimony? It seems they were a little inconsistent, the two plaintiffs, in their testimony.
I don't really think so, Your Honor. They were different in their recollection of whether there was an exact amount that Mr. Perry agreed to fund. But Mr. Perry said that he agreed to fund up to the maximum costs that they had discussed as the total cost of the project, which was $4.8 million. And Mr. Gray said, well, I don't remember whether it was exactly that amount. He didn't sign a blank check, but he agreed to fund it as long as the costs weren't out of line. Now, he said that repeatedly. He agreed to the deal. He agreed to fund the project. He agreed to fund the whole project. And at the very, very end, after a great deal of cross-examination, what he said and what the defendants have hung their hats on is that there would have had to have been a definite amount before he would have agreed to anything. But at that point in the testimony, they'd been talking about having reduced, why didn't he reduce the partnership agreement to writing? And I don't frankly think that the jury, which heard it all, had any reason to think that that was inconsistent with his prior testimony or the testimony of Mr. Perry. So no, I don't think they would have had to believe one plaintiff over the other, or even that their testimony was in any significant extent inconsistent with each other. Kislak requires nothing more that there be an agreement to carry on a business for profit as co-owners. It was a case on a motion to dismiss about whether the elements of the case of a partnership had been properly alleged. It did not require, which is what defendants argue now, that in a partnership case, a trial judge must instruct on every element of a contract in order to go forward on whether there was a partnership agreement. So we're not taking the position that Kislak is bad law, because Kislak has never stood for what defendants would like it to stand for now.
What's the standard of review on the trial court's decision to not give their requested instruction?
Well, it's nominally an abuse of discretion standard, but the courts have been a little more clear about exactly what is required. And what is required is that first of all, the instruction that they request must be an accurate statement of the law, which this one was not.
What's wrong with it?
What's wrong with it is that it overemphasizes one portion of the agreement to enter into a partnership. It's an agreement to carry on a business for profit as co-owners. And that was given, that element was given, that was not objected to. It included the finding that it could be implied and that, in fact, it could be the parties may not have had the subjective intent to form a partnership as long as they intended to do those things which constitute a partnership, which is share profits and losses, have a community of interest, have joint control. And this meeting of the minds instruction was an additional instruction which improperly emphasized, in a very confusing way, one particular element, which is the agreement element. It's very difficult to give in one piece of your instruction, which they agreed to, which is a proper statement of the law, that they might not even have intended to form a partnership, and on the other hand say, and oh yeah, by the way, they have to have agreed on every specific detail, and they have to have a meeting of the minds, and the judge was correct in his very simple statement, that's not the law. In addition, the meeting of the minds instruction, which they requested to be given, was not just meeting of the minds, but it was emphasized that there had to be specificity as to every term of the agreement, and went on to emphasize particular portions, particular ways in which an agreement might not be sufficiently specific, and yet it didn't instruct on another element of contract formation, which is consideration. It was a bad instruction. The court was correct not to give it. It was argumentative. It wasn't a correct statement of the law. It overemphasized one portion of the testimony and not the other. Moving on to unjust enrichment.
Back to my question, though. So you're saying nominally it's abuse of discretion, but the appellate courts have actually required a stricter standard of review than abuse of discretion?
Yes. The party claiming reversible error for failure to give a jury instruction must show that the requested instruction accurately states the applicable law, which this does not, and that there was evidence and testimony that supported the giving of the instruction, and that the instruction was necessary to allow the jury to properly resolve all of the issues. If you fail number one, I would argue that you necessarily fail number three. If it's not a proper statement of the law, then it can't have been necessary to allow the jury to properly resolve all of the issues. And in fact, again, this particular instruction would have been extremely confusing to the jury, which had just been instructed previously without objection that an agreement could be implied and that the parties might have formed a partnership even without the subjective intent to form a partnership. With regard to unjust enrichment, the plaintiffs have not conceded at all that there was a lack of evidence of the value of their contribution. The issue is, how is that measured? The proper measure is whether or not is the amount, the value of the benefit conferred to the party upon whom it was conferred. Now, their argument was the only way you can show that is by showing the cost of the time contributed and the cost of the materials contributed. That's a quantum Merowitz standard. That is not an unjust enrichment standard. The value of the plaintiff's contributions to Anchorage development is properly measured in this case by the profit realized from the project by Anchorage development. Anchorage development and Mr. ZETLEY threw these guys off the project without so much as a fare thee well. And then they told in letters to the people who had provided deposits for these condominium units that that my clients had been bought out. At the end of the day, Anchorage Development realized all of the profits from this development, and none of those would have been possible but for the efforts of Mr. Perry and Mr. Gray, who found the property, put it under contract for a favorable amount, had the plans drawn up, sold the project, then sold the project to Brevard County and obtained the site approvals. Without those actions, there would have been no profits. Arguably, the plaintiffs in this case would have been entitled as damages for unjust enrichment to 100% of the profits. But the cases have said, and the Montage case says, that if you have an agreement with respect to a project or a contract that either is not admissible or is legally deficient, then if it limits your interest in a project or in the profits to a certain percentage, then that's really all you're entitled to get. And that's all we claim is half the profits, and that's what the jury awarded. And you don't have to go to Montage to find this measure of damages. There's actually a 1928 Florida Supreme Court case, the Hazen case, which we cite in our brief. It's 117 Southern 853, which specifically says that frequently the invalid contract is admissible as to evidence of the value of the contribution. And in fact, that's what has happened here. With respect to prejudgment interest, the law is very clear that once a finder of fact has determined the amount of the damages, the plaintiff and the defendant's liability, the plaintiff is entitled to prejudgment interest as a matter of law. The verdict form need not specifically provide a date for the jury to find on which those damages are liquidated, as long as there is evidence in the record that permits the court to determine when those were due. And in this case, the amount of the damages awarded was approximately half of what plaintiff's expert witness had testified were the profits to Anchorage Development in this case. And they were exactly the amount that Anchorage Development claimed as expenses for the lawsuit on its 2004 income tax return. So that being...
Minus the attorney's fees to date?
Minus the attorney's fees to date. Once you knocked out those attorney's fees, which were also in the record, the net amount was $751,000, and that is exactly the amount that the court awarded. The testimony of the accountant was clear that the only valid reason for deducting that from their tax returns would have been if they owed the money. The jury heard that testimony without objection, and that is the exact amount they awarded. So awarding prejudgment interest as of January 1st, 2005 was supported by the record in this case and required by the law to have been awarded. If you don't have any other questions, I think I'm done.
Thank you.
Counsel says quite correctly that there was nothing in the proposal requiring a guaranteed maximum price contract, but I suggest that just shows again the absence of an essential term of how this project was going to be built. Moreover, a guaranteed maximum price contract was the only way that Mr. ZETLEY could be assured of that which Mr. Gray himself admitted was a requirement of Mr. ZETLEY, that the construction cost makes sense, that it be in accordance with the preliminary budget, and instead the plaintiffs came forward with a cost-plus contract that was not in accordance with their preliminary budget, and they acknowledged that there had to be continued negotiation of that contract. And that, Judge, is what was so prejudicial about the absence of the very limited, narrow instruction that's at issue on this appeal, which was that the jury was never instructed on the effect, the legal effect, of the parties continued negotiations of that contract. The instruction itself on the issue that it addressed was completely accurate. You have to have a meeting of the mind on the essential elements of a joint venture, and if you're still negotiating on those elements, you don't have an enforceable joint venture. There was nothing in that contract, in that instruction, that suggested that you had to have an intent to form a partnership. It was completely consistent with everything that came came before it. It simply said you had to have a meeting of the minds on all of the essential elements, and that if you were still negotiating those, you didn't have an enforceable contract. They did, as on unjust enrichment, there's no question they provided services, but so did Anchorage. This project wouldn't have been constructed but for all that Anchorage did to construct it, to sell the units, to complete it, to stand by the warranties. It would never have been built but for that. So to give the plaintiffs a part of the profits from the project that Anchorage itself built is to unjustly enrich them. All they were entitled to was the value of the benefits of their services. To the extent they argued, counsel has argued there was an interest in the project, that assumes proof of a joint venture, and if there was a joint venture, then of course you don't get unjust enrichment. Thank you for your patience today.
Thank you, all counsel, and please enjoy the holidays. We're adjourned.